So we're going to go ahead and call our meeting to order. I want to thank all of you for being here today. This is the House Study Committee on Compensation for Wrongfully Convicted Persons, and this is our second meeting. We heard from several of you in our first meeting. We have some follow-ups that we're going to do this morning, but we have someone who was not with us the last time who wants to weigh in on this subject, and we're going to yield the mic to Michael Owens, Dr. Michael Owens, and he's an associate professor at Emory. So you can come, you can be seated if you like, or you can stand over there, whichever is your preference. Good morning.
So first, I just want to thank the House Study Committee on Compensating Wrongfully Convicted Persons, especially its chairperson, for allowing me to testify today. I'm Dr. Michael Leo Owens, Associate Professor of Political Science at Emory University. I'm also a member of the Board of Directors of the Prison Policy Initiative, a think tank that is nonprofit, nonpartisan, that works to improve criminal justice reform through research. I come before the study committee as a scholar of ex-prisoner reentry and the politics of punishment in the United States. I have a particular interest and focus in wrongful convictions. You may not know it, but our nation recently celebrated an important anniversary, the 100th anniversary of the first enactment of statutory compensation by states. In 1913, California and Wisconsin became the first states to enact statutes for compensating citizens for wrongful convictions. They were the first to decide to create systematic financial restitution for the wrongly convicted. 101 years later, as we know, Georgia still stands without having made a decision towards that end. In many ways, that's actually quite odd. Georgia has become a leader among the states in reforming criminal justice, particularly punishment. Think of the last 2 years. The state made amazing, even surprising reforms to the adult correctional system in 2012 and the juvenile correctional system in 2013. Georgia, however, has been slow to reform its approach to compensating those that the courts have ruled wrongfully convicted and unjustly imprisoned. Nonetheless, it's heartening that the Georgia legislature created this study committee. It's also heartening that the legislature, as the General Assembly stated in its resolution, in creating the study committee, is sympathetic to the tremendous burden a wrongfully convicted person faces and finds that there is a need to create a uniform method of fairly and reasonably compensating wrongfully convicted persons. In many states, including ours, the unjustly convicted, as judged by the courts, have a hard time distinguishing themselves from what we could say were the justly convicted. Like the rightly convicted, the wrongly convicted bear the mark of a felony conviction and the stigma of imprisonment. Furthermore, government agencies, many nonprofit organizations, and neighbors often view and treat the wrongfully convicted as discredited and scorned citizens of the state of Georgia, unworthy of our collective assistance and empathy. Therefore, as we know, exonerees face the stigma of being an ex-prisoner and re-entering society as an ex-offender, but does not qualify for compassion and services offered to almost all ex-offenders in the state of Georgia. Consequently and strangely, in an age when state governments like Georgia's willingly spend tens and hundreds of millions of dollars on institutions to try to positively integrate the justly convicted back into society, it sparingly spends on individuals wrongly convicted of crimes. Such individuals must scrape and toil and fight for arguably paltry portions of state dollars to positively try to reintegrate themselves. They must do this despite the special sacrifice they've been compelled to make in the interest of the public, the loss of their liberty. As one legal scholar commented in 1932, the least that a state can do to vindicate itself and make restitution to the innocent victim is to grant him an indemnity, not as a matter of grace and favor, but as a matter of right. Private legislation, however, which is what Georgia relies upon to assist the wrongly convicted, trades in grace and favor. Georgia requires lobbying by or on behalf of the wrongly convicted to obtain a legislative sponsor and broad legislative support for a bill that will provide them, hopefully, with restitution. But such action, as legal scholars observe, is spasmodic only, and not all persons have the necessary influence to bring about legislation on their behalf. Beyond the unpredictable nature and outcomes of private legislation, legislative access, influence, and success vary among the wrongly convicted. Policymakers and the public may view some of the wrongly convicted more positively than others. Also, some of the wrongly convicted may have considerably more public support than others, which they can convert to political capital and leverage in the legislature. And that is unfair. Furthermore, legislative discretion in granting compensation is problematic. Although scholars and advocates focus...
Excuse me, 1 second.
I'm sorry. Yes.
For purposes of recording,
Yes.
they're saying your mic is not on. Would you check
Oh.
that mic?
Hello? Hello?
Okay.
Much better? Sorry about that. Speak into it. Okay. I'll stop speaking into my chest. Project. Furthermore, legislative discretion in granting compensation is problematic. Although scholars and advocates focus attention on legislative influence over amounts of compensation, private legislation may also manifest paternalism towards and regulate the behavior of the wrongly convicted. For instance, during the 2009 legislative session in Georgia, the General Assembly passed a resolution to award $500,000 over 20 years to Mr. John Jerome White. Mr. White was wrongly convicted of the burglary, rape, beating, and robbery of an elderly woman. The state chose to compensate him for, quote, loss of liberty, personal injury, lost wages, injury to reputation, emotional distress, and other damages as a result of his 28 years of incarceration and expenses in trying to prove his innocence, totaling $3 million. Compensation of Mr. White, however, also came with post-exoneration scrutiny and regulation. The General Assembly mandated that Mr. White submit to random drug tests and remain in the labor force, i.e. employed or seeking employment, and or volunteer with a nonprofit organization during his 20 years of compensation. In short, the legislature placed an exonerated man on quasi-parole. Beyond the possibility of private legislation being a tool of paternalism and wrongful regulation of personal liberty, private legislation is often among the slowest forms of legislation to pass. For example, it took 20 years and the introduction of 4 bills for a Florida legislature to pass legislation acknowledging the entitlement of equitable relief of 2 wrongly convicted men. In Georgia, compensation is sometimes quicker, but still slow if it happens at all. Calvin Johnson, for instance, waited 5 years for compensation from Georgia, stemming from a wrongful conviction that imprisoned him for 16 years. Ultimately, moving from the scheme of private legislation to a system of statutory compensation in Georgia would remove grace and favor from the calculus of compensation. Such a reform would privilege right, entitlement, and reason. In other words, statutory compensation would allow the General Assembly and the governor to manifest the state's motto on behalf of the exonerated: wisdom, justice, and moderation. The federal government encourages the states to provide reasonable compensation to any person found to have unjustly convicted of an offense against the state. Today, a majority of states, 60%, have statutes that permit and provide for compensating the wrongfully convicted, or have revisited their statutes to actually strengthen them. That's in addition to the District of Columbia and the federal government having compensation on their books. I have a graph to share with the study committee. I didn't know how many people would be here, so I only made 10 copies, but if you, this will help you follow along with what I'm about to cover. This graph shows the enactment of wrongful conviction compensation statutes across the states from 1900 through September 2014. As you can see, there was the long period of stability, approximately 70 years, when almost no states enacted statutory compensation. Then, beginning in the early 1980s, states began to enact statutory compensation, and since then we have witnessed a spate of enactments. We also have not seen a single abolition of wrongful conviction compensation statutes, especially over the last decade. Between 2000 and 2006, between 2000 and today, 26 states adopted some form of compensation law. 20 of those states did it since 2006, bringing the total number of states with any statutory compensation for wrongful conviction to 30 states. The last 3 states to enact statutory compensation were Colorado in 2013, Washington in 2013, and most recently in 2014, the state of Minnesota. Interestingly, most states in the South have enacted wrongful conviction compensation statutes. 11 of the 16 southern states have compensation statutes. This set includes states known to have the toughest correctional systems in the country. Texas, Alabama, Florida, and Mississippi are among them. Moreover, 8 of the 11 southern states that have enacted such compensation statutes have done so since 2001. Furthermore, most states governed by Republicans, that is, having Republican governors and/or majority Republican legislatures, have wrongful conviction compensation statutes. Clearly, other state governments have been able to forge GOP-led reforms or bipartisan coalitions for reform. Georgia, however, remains behind the curve. So there has been what we could say is a cascade of compensation statutes across the states. Generally, this is because of spikes in exonerations, particularly DNA-based exonerations across the states. My own published research with criminologist Elizabeth Griffiths at Rutgers University suggests that the number of exonerations in a state best predicts whether it has a compensation statute on the books. States with more exonerations occurring in them are more likely to have a significantly higher probability of having a compensation statute. An obvious interpretation to this finding is that states are increasingly likely to enact compensation legislation to remedy wrongful convictions as these miscarriages of justice are identified and corrected. However, we can imagine that some states also have statutes because they reason, probably correctly, that the budgetary consequences of enacting statutory compensation are very limited. Because A, there will probably be low demand for recompense as a consequence of few exonerations in the first place, or B, they retain the discretion to have high bars for compensation, which actually reduce the pool of exonerees eligible for compensation. We must recognize that not all compensation statutes across the United States are the same. The result is statutory compensation may yield inequities in terms of access to compensation, that is, especially eligibility and restrictions, as well as the amount of compensation available. Some state laws include very weak provisions for the amount and quality of compensation. The compensation statute in Montana, for example, makes no provision for direct financial compensation while offering indirect financial assistance in the forms of fee waivers, educational scholarships, and tuition payments for secondary education, post-secondary education. In most states, compensation awards may even be taxable as income. Overall, 81% of those who have been exonerated by the courts that have received compensation received less than the federal standard of a maximum of $50,000 for each year of unjust imprisonment. Some states do and some states don't allow for cost of living adjustments to compensation. No state in the Union provides a suite of compensation assistance that accord with the model proposed by the National Innocence Project. Analyzing statutory compensation in the 27 states that had enacted it up until the year 2011, criminologist Robert Morris at the State University of New York at Albany concludes that monetary compensation is near universal, with Montana being that outlier. However, approximately 50% of states with statutory compensation cap total recompense for wrongful convictions. These range from a low of $20,000 to a high of $2 million, with a median of $400,000. Additionally, only 57% of the states with statutory compensation supplement monetary restitution with non-monetary compensation, like subsidized health care, job training, and tuition waivers. Additionally, most statutory compensation systems ignore the importance of expunging wrongful convictions, clearing or sealing the records of the exonerated. To date, 39 states do not have expungement statutes that are specifically tailored to the wrongfully convicted. And Georgia is among those 39 states. That seems unfair, given that Georgia enacted a law in 2012 that strengthens restricted access to non-conviction records for people charged with crimes. Many expect the state to consider reforming the First Offender Act in 2014 to allow for certain classes of offenders to receive record expungement for good behavior and other reasons. According to one well-regarded research study, almost 1/3 of exonerees do not have their records purged. Moreover, as the study goes on to show, failure to expunge was a significant predictor of post-exoneration offending. This relationship was strongest for offenders who had not committed an offense prior to the one for which they were wrongfully convicted. So it sort of speaks to the precarious nature in which many of the exonerated find themselves after being released from prison and not having access to some form of compensation.
Professor, can we stop you at this
Sure.
juncture because I have a member who's going to have to leave us early?
Sure.
And let me see if any of our members have any questions for you at this point. No, we're good?
I have several, but I can wait till the end.
Okay, go ahead.
Thank you. Although statutory compensation may come closest to an ideal means of fulfilling the societal obligations to the wrongfully convicted, it yields grossly uneven compensation for exonerees across the states that provide for it. In other words, the quality of compensation is higher in some states than in other states. Why? To start to answer the question, Elizabeth Griffiths and I, in another published study, employ what's known as Norris's Quality of Statutory Compensation Index to identify factors that may influence the comprehensiveness and value of statutory compensation. The index measures, as of 2011, various dimensions of statutory compensation: amounts of monetary compensation, categories of social assistance such as employment, mental health services, attorney fees, and the like, criminal record expungement, eligibility criteria, disqualifications for assistance, statutes of limitations, tax provisions, on and on and on. The index also scores the quality of statutory compensation by states against the model proposed by the National Innocence Project. A state with statutory compensation meeting the standard of the model would receive a score of 60. Of the 27 states covered by the index, the highest score is 43, earned by the state of Texas. Based on our earlier research findings, we were keenly interested in whether or not the number of exonerations in a state influenced compensation quality. We included data on the 275 DNA-based exonerations facilitated by the National Innocence Project. Our statistical analysis suggests that the quantity of state-level exonerations strongly predicts the quality of state-level statutory compensation. Specifically, as the number of DNA-based exonerations increases, the quality of statutory compensation for wrongful convictions rises. Indeed, Texas, the state with the largest number of exonerees, has the highest score on this index. Texas truly is the state with the best statutory compensation system. It has no rival. In 2009, the Texas legislature increased the annual recompense available to its wrongly convicted citizens to $80,000 a year, which is $30,000 above both the amount the federal government provides for wrongful convictions and the amount that the National Innocence Project itself lobbies for in state legislatures. Moreover, Texas provides the wrongfully convicted with $25,000 for every year of parole and or being on a registered sex offender list. Furthermore, Texas allows for monthly payments, following an initial lump sum. It even allows for leftover compensation to be distributed to the estates of deceased exonerees. Additionally, the wrongfully convicted in Texas are entitled by statute to reentry and reintegration services that the justly convicted receive, awarded tuition scholarships for up to 120 hours of credit at a public university or college, which is enough to earn a bachelor's degree, have the option to purchase low or at least lower cost health insurance from the state's employee health plan, and receive compensation for child support payments. However, and perhaps rightly, Texas prohibits compensation for the wrongfully convicted if concurrent with their wrongful conviction, they were imprisoned for other crimes that they did in fact commit. Despite inequities across the states with statutory compensation systems, advocates for the wrongfully convicted still favor statutory compensation. This is mainly because it reduces the degree to which legislative discretion and even politicking dominate the process of recompense for wrongful convictions. Before I conclude, let's remind ourselves of the beneficiaries of compensation. The payment of the public debt to the wrongly convicted for the taking of their liberty for public use is intended to repair and compensate for as much of the damage wrought by miscarriages of justice as possible. This reparation has three beneficiaries. The first beneficiary of reparation is the wrongfully convicted individual. The intent of payment for their unjust conviction is to make amends for the miscarriage of justice, to allow the victims of it to recoup financial losses, to reduce the economic vulnerability of the victims, and to increase self-sufficiency after release from imprisonment, inclusive of parole and probation. A second beneficiary of reparation is the government. Payment to the wrongfully convicted is a down payment for repairing damage done to the state. Compensation serves as acknowledgments of miscarriages of justice either by government or by juries on behalf of the people. Reparation of the wrongfully convicted burnishes the public legitimacy of government. Reparation allows it to rightly retain or even regain public respect for its criminal justice institutions and the rule of law. The monetary cost to states compensating the wrongly convicted may also reduce the likelihood of further miscarriages of justice, right, functioning as a deterrent, improving the moral performance of the courts and other institutions of criminal justice. And the third beneficiary of reparation is, in fact, the public. As the observer of miscarriages of justice performed in its name, reparation for the wrongly convicted likewise restores public confidence in the ability of judicial, correctional, and legislative institutions to exercise good judgment and fairness. Thank you.
Thank you so much, Professor Owens. We appreciate your presence here today. Will you share your presentation with us?
Certainly.
And there is a couple of questions. We'll start with Mr. Allison.
Professor, I appreciate you being here.
Thank you.
Since this is kind of somewhat of a field that you've got incredible amounts of study in, I wanted to ask you a couple questions, see if you would have the answers for those. Just first, I guess one, I'll go off your graph. It's obvious that somewhere in the 80s there was a spike in the number of states who decided to adopt statutory compensation. Do you think that correlates with the rise of DNA testing and the ability to concretely assert someone's innocence?
Most definitely.
Okay.
I don't think there's any question at all that much of the impetus for the adoption of these statutes from the 1980s forward were directly related to the presence and discovery of more wrongful convictions because of DNA. However, I would also say that not all of the states that have enacted such statutes strictly rely on DNA exonerations. There are states that also acknowledge the idea that factual innocence, even in the absence of DNA evidence, is actually possible. I also think that we could imagine that at the same time in which more scientific explanations account for why we see these statutes being passed, I think also just we think about sort of popular culture mattering as well, and the variety of films, for example, that have gone on to pay attention and raise awareness in the public around the question of wrongful convictions and the idea that exoneration is possible and that reparation is necessary.
I guess I'll ask this question because you had mentioned it before. In your studies, what percentage of those who have received compensation would you say this was their first offense? Because you had mentioned that before in your speech, and it just made me write down a note. I was kind of curious.
Offhand, I don't have an actual number for you. What I would say is, based on my knowledge of the literature and scholarship around these questions, that most people who have in fact been exonerated of wrongful convictions had never been offenders before their wrongful conviction. I would be willing to state and allow a follow-up down the road to verify this or not. I'm quite sure that it's the majority of exonerated people.
Okay, and we had a discussion at our first meeting, which I'm glad you're here today. How do other states handle compensation of attorneys? Because oftentimes when someone brings a lawsuit, it almost becomes like a personal injury claim. I'm a lawyer myself, so I agree to take on John's case for a certain percentage. So the state ends up paying a nice sizable chunk, and we actually have an issue right now with one of Georgia's wrongfully convicted that's actually in a fight with his attorney. So do other states get into the attorney compensation, or do they just does that remain between the wrongfully convicted and his attorney?
It really depends on the state.
Okay.
There are some states that have sort of thought through the idea
Right.
that attorneys' fees should be included as a form of compensation restitution for folks. There are some states, however, that remain quite silent on this issue, choosing to leave it up to the client and their attorney to handle this situation.
Well, obviously, in certain aspects of the law, maybe workers' compensation, for instance, we cap the amount an attorney can recover, so that we make sure the majority of the money goes there. And I think that is a concern that we have.
There are also, though, I mean, to the issue of the cap, I mean, so that's one way to think about what the cap does.
Right.
It's possible in some contexts, though, that the cap also makes it more difficult for the exonerated person to eventually be able to actually identify a lawyer who would help them move forward. I mean, this is in particular the case, I think, with regards to what we currently do in Georgia with private legislation. Really being able to have to beat the bushes to find someone to really stand with you as your champion and move forward in the state legislative process.
May I have one more question? I actually have two more, but I'll start with this one. Then see if anybody else wants to talk.
You sound like a professor.
I noticed during your presentation that it seems to me that you're, and maybe I don't want to put words in your mouth, that you're advocating kind of a symmetry between not only a compensation resolution, but some kind of expungement legislation. I take it you would advocate that if we were to pass one, it probably would be in the best interest of everybody to pass the second one at the same time, one setting forth what our guidelines for compensation would be, the other to kind of, I don't know if we want to call it fast track, but put into some place an expungement, because you keep mentioning there's a time lapse even between the time when someone is considered wrongfully accused and this lingering process of expunging that record. Did I misunderstand that, or is that kind of what you were advocating?
No, well, what I would say is, in terms of what I would truly advocate, I would actually truly advocate some sort of no-fault compensation system. But that's very difficult to try to enact, and no states have such a thing, right? But if we can advocate for something, in addition to just simply compensating someone either financially or non-monetarily, to me it makes a lot of sense that we also think very seriously about expunging people's records, right? Because we know from all of the biographies and autobiographies of exonerated people the challenges that they actually face. Even within their own families, there are people who still wonder whether or not X person really did or didn't do a particular crime. There is this idea that people just simply got off on a technicality in some way, shape, or form. I think that expunging someone's record allows that person to have more of a covering provided by the state, that we are to actually judge that person to have been unjustly convicted and to actually treat that person with full compassion and support in the communities in which they return to. And I would also think that this would definitely be useful to assisting people in being able to do basic things, like simply get a job, like simply be able to find affordable housing for themselves, and a variety of other things. So I think expungement is also very, very important. And again, I mean, we have had in the legislature a number of efforts to bring forth expungement bills that speak to people who have been arrested but not convicted of crimes, right? And so we've done good with that. There are others now, though, who are, again, would like to see the First Offender Act reformed to allow for the First Offender Act to allow for certain forms of expungement for people who have been rightfully convicted. So if we can have that conversation, I don't see why we can't have the conversation about expunging the records for someone who was, by the courts, judged, wrongly convicted.
One last question, I promise.
Sure.
That I had presented this question to Ms. Maxwell, who's I'm a big fan of what she does because she does not have an easy job, and we've met several times. Some of the problems that I have faced in my 6-year career here and in talking to other members on the floor who have issues with these types of resolutions stem from the fact that in none of the cases we've had in Georgia, thank the Lord, have we seen any prosecutorial misconduct. In essence, they played the cards they were dealt, and oftentimes there was nothing that directly linked the state's advocates, that being the district attorney's office, from having any hand in wrongdoing.
Yes.
Which is causing concern on some of the members that if it is a tragedy these people got wrongfully convicted. However, if we as a state didn't do anything wrong, and our advocates, that being district attorney's office, didn't do anything wrong, how do we give them money? How do we go back to our colleagues and sell this?
Sure.
Because I can tell you my heart's changed in several months, and that I'm looking at this from a completely different aspect. But I would also like some fodder because, I've been a practicing attorney in this county, in the state for 17 years. And primarily I was a criminal defense attorney. So I have a good relationship with all my district attorneys because I know that they have a tough job. but it's been hard for us to sell people, especially even more conservative people like myself, on the fact of giving compensation when the state had no wrongdoing in there.
Mm-hmm.
How do we present that, would you say, in your expert opinion?
Well, one, it's perhaps Georgia has just simply been fortunate and lucky that to date there hasn't been a clear-cut case of wrongdoing by prosecution. The second thing I'm thinking of is juries. I think it's curious that people entrust the juries to do the work on behalf of the people, the state, and when juries wrongfully convict or contribute to the wrongful conviction of people, somehow we then say, oh, but wait, the jury really isn't sort of an arm or a connection to government. It's this sort of weird space between government and civil society or something like that, which to me doesn't make a lot of sense. If you ask most jurors what they think they're doing in the courtroom and in the jury deliberation room, they think they actually are working to help the state. I also think with regards to this issue, in some ways, perhaps, maybe we just toss it up to fortune. We do this all the time, in fact, as a state. If we think about acts of God, and we think about destruction of physical property that had nothing to do with the state, yet the state is willing to provide compensation for a variety of business owners, homeowners, and other property owners. If we can do that for property, I don't see why we can't do that for people. And, you know, if you've got folks who still aren't willing to buy those arguments, I mean, I'm not quite sure how reasonable I could judge them to be.
Appreciate your time, sir.
Thank you.
Mr. Mayo or Mr. Harbin, either one of you all have questions? Let me just thank you, Professor, for being with us today. And of course, we want to have a copy of your presentation, and we thank you for your research and for your interest in this particular subject.
Thank you.
I'd like to pause and recognize the presence of Senator Harrisina Tate, who's joined us today. And she's worked on some of these issues on the other side of the hall, on the Senate side. Do you have anything for us, or are you just visiting? Thank you so much. Thank you so much for being here. We're going to go to our updates from our meeting. Last time we asked a few people to bring us back some information for the benefit of the committee, and we're going to start with Robert Seals. You can go down there. If you're going to talk a long time, you need to go down there. Or you can stay. You can stay where you are. That's fine. Just tell me your number.
Thank you, Madam Chair. And not to belabor any of the points that Dr. Owens made, but our office has compiled some information that we think would be of use to the members, including a table laying out the statutes for, or lack thereof, for all 50 states, with a particular focus on sort of the holistic approach mentioned by Dr. Owens as far as addressing educational compensation and expungement. One thing that we have included is a lot of language from various states, both that we feel are good or poor examples from what they've been able to do. And just to reiterate Dr. Owens' point as well regarding expungement in Georgia, the process generally takes minimum of 60 days. That's on the bright side. And also, in sort of an ironic note, calls to the Fulton County Office of Expungement from our office have gone unreturned for a while now. So, you know, it's something that we would certainly encourage the members to look at, and we've provided that information as well.
Well, let me just say on my experience with expungement when helping a person, they filed the paperwork, it got lost. They filed it again, it got lost, and it took more than 6 months for that expungement process to go through. In the meantime, the person was hampered in his ability to look for work, as the professor said, and to reintegrate themselves into society, even though the courts had said that they were not guilty of the crime. So that is a challenge because of the number of people that have to sign off on it as well. Everybody has to agree, first of all, and then after everybody agrees, the process sometimes takes a long time.
That's all I have, though, unless there are
Okay,
any questions.
if you'll just share that with the committee.
Sure.
Anybody have any questions for Robert? Okay, thank you so much. Ms. Maxwell. Amy Maxwell is the executive director of the Georgia Innocence Project, and she's going to come back to us with some information. And of course, we all know that the Innocence Project has some standards and recommendations for states to follow, and she's going to bring us back some additional things. Let me see if I can get the right mic on for you.
Is it on? I think it's on.
Okay.
Well, one of the things that you all wanted to know more about was what other states are doing, particularly the states around us. And I am absolutely not going to steal Tara's thunder because she put together an excellent report for all of you on what all of the states are doing. One thing I want to do before I forget is I thought that the presentation was amazing this morning, and there were a couple of things that I kind of wanted to give you guys some clarification on. Actually, the first DNA exoneration was in 1989, so all of those statutes in the 80s were actually states recognizing that innocent people go to prison no matter what. It wasn't just driven by DNA testing. So obviously, since 1989, DNA has been in the forefront of talking about wrongful conviction, but wrongful convictions were happening before then. Also, I really did, I found in my heart, I love the fact that there was an equation between number of exonerations and compensation statutes, meaning that states were looking at this and saying, oh, this is a problem, we need to help with it. I think there's also a point at which states look at it and think, oops, lawsuits are coming. The more DNA exonerations there are, the more likely those states are to recognize the fact that if lawsuits start coming in these cases, the compensation is going to be much higher than the state. So I think it's a real I think there's a real correlation between recognizing lawsuits and realizing we need to keep the state's liability limited. And that's what compensation statutes do very well, is limit the state's liability. Two of the things that he talked about were child support. I hadn't mentioned child support before, but Clarence Harrison actually got sued for child support by the state for the time he was in prison. And let me tell you, that was a what when that happened. And I had to find a lawyer who knew about child support. And he did have like a couple $100 he owed before he went to prison, so we paid that. But even the child support people were like, I don't know why we have to go to court on this. This doesn't make any sense. So it would be really good to have just that acknowledgement that if the state is shouldn't go after child support for these people who have been in prison wrongfully. Also, attorney's fees. Obviously, we've represented most of the DNA exonerees, and yay, get some attorney's fees. But I will tell you that it is a frightening process to come before you all. Particularly if you don't know what you're doing. There's a lot of things that a lawyer needs to understand before they bring a bill before the legislature. So having some attorney's fees might encourage lawyers to learn about it and to learn about the process and how to make it better. I also don't know that I was thinking about this during the interim and thought nobody's really talked about the process of how this goes through the compensation, Claims Advisory Board, and just kind of the procedures. And I know that you've been through that, but what happens is you have to file early in the fall to go in front of the claims advisory. So that means if I had an exoneration today, I'd have to probably wait until next fall to put in the paperwork, because I won't have all the necessary papers from the courts, and I wouldn't have the plan on what we were going to do with the legislature, so I'd have to wait a whole other year. Then you go in front of a board that's made up, I know it's the Department of Corrections, the Department of Transportation, and there's another department that's represented, and I suspect those are the three departments that are most often sued.
Administrative services.
Okay, administrative services. So, and all they do is confirm that this is a legitimate claim against the state. They don't look at how much the claim is for. And then so that's the process before it gets to you all. So, as you're thinking about this, there may be a better streamline of how to get these compensation statutes in. And finally, you all talked a lot about expungement, and expungement is a long process, and it doesn't necessarily have to wait till compensation. But I would think that if the legislature is willing to give someone compensation for being wrongfully convicted, at that moment, if those records haven't been expunged, there could just be something in there that says, if we acknowledge you've been wrongfully convicted, your records get expunged today. You know, you don't have to go through the whole you could go through the whole expungement process before you get to the legislature.
Well, question, Amy. Why couldn't the judge just, if the judge has overturned the case and say you're not guilty, why couldn't they expunge the record automatically at that point?
I have not personally done an expungement. I've had, volunteer lawyers who do that with me. But I think that there's a procedure that it has to go through to the DA's office and then to
it has to go to DA. The judge has to sign. The DA has to sign. The GC, whatever that system is, that administrator has to sign off on it, and then they process it. But I'm saying, why couldn't the judge direct that the record be expunged at the point that they say the person is not guilty?
Well, here's the thing. If I were thinking ahead rather than just being so excited about getting someone out of prison, I could probably get a consent from the DA in front of the judge in that moment and get it done at that moment. So I think that there's probably a very quick process if the DA on the case is willing to sign off on it in open court and the judge is willing to order it. I think that's possible, but I don't know that process. I will tell you that I mentioned earlier that I usually have lawyers come in and work through the compensation legislation with me. Those are always, in my case, always volunteer lawyers who work at big law firms who already have a role in their legislative lobbying. That they come in and help me. I think for instance, a personal injury lawyer coming into the legislature would be overwhelmed by the process. I know I feel overwhelmed many times. So those are the things that happened today that I wanted to address. And honestly, I had my notes and I couldn't find them yesterday to make sure that I had addressed everything you wanted me to address. So if there's any other questions, because I've been in communication with Tara, and she's, like I said, done a really good job on what other states are doing.
Okay. Do any of our members have any questions for Amy today? No? Okay.
Thank you, Madam Chair. Amy, what are your thoughts on how the state should respond in the situation where there's no prosecutorial misconduct? The gentleman mentioned that the jury is sometimes an extension of the state, or at least they consider themselves to be acting on behalf of the state. And then another, kind of argument would be that in the case of natural disasters, at times the state compensates citizens. Do you have any additional thoughts on how we could kind of frame that?
I thought the natural disaster analogy was quite an amazing analogy. I thought that was really good. But the other thing that we all need to remember is these people didn't go to prison because there was no DNA. They went to prison because of other investigative tools that maybe the police weren't doing the best job investigating, or maybe there were things that were missed. Maybe there are policies in place that made investigation not as effective, and those policies may have a state root. I am not a personal injury lawyer, but I know that they are quite clever. I think that there are, while I don't see a lot of, that there's any state misconduct, I suspect if personal injury lawyers get a hold of these cases, they may find other things that are at fault that have a state nexus. And I certainly think that's what other legislatures have seen, is that, and I will tell you, when these cases go to a jury, the compensation is high. I'm glad you asked that, because I had one thing and I've forgotten to give you all. I brought you the economist's value of an economic loss that they did for Clarence Harrison. And Clarence, as you may remember, was compensated at $1 million. What the economists put the value of his loss at was $2,082,012. So twice the amount that the state gave Clarence is what the economist valued his life during that time at. And if he were going to trial in front of a jury, that is what the economists would say the value of his life had been, and that doesn't even include if they found for the wrongfully convicted the punitive damages that can be leveled. So and the things they looked at were income, pension, health, life insurance, and Social Security, which is, as we're finding, quite a challenge for our guys, that they don't have that Social Security background. So I will give you these, and you can use those as part of your decision making.
One question for you. We talked last time about the recommendation of the Innocence Project around the $50,000 number, and of course that recommendation has been out there for some time now. Do you have any thoughts on where are we still at the $50,000? Is that still the recommendation that you would suggest based on the Innocence Project prior recommendation, or is it something else?
I did a highly scientific Google search yesterday, and $50,000 in 2008, which is, obviously all of us, for the economic reasons, there's 2008, but also that's really kind of, a point at which there were many statutes in place. Mm-hmm. And I believe that was, the end of President Bush's time in office, and President Bush is the one, his administration said 50,000. If you look at what 50,000 was then, 50,000 now is 55,000. So it's gone up basically 10% in cost of living and everything. So I think that there's a good argument to consider cost of living as we look at where we're going to compensate now, because 50,000 what's it been, at least 5 years, 10 years, 7 years. I can't do math. Just exposed myself. 6 years.
6 years.
Thank you. 6 years from that. So I do think that there's an argument to bump it up some.
Okay. Anything else for Amy? Thank you, Ms. Maxwell. I'm sorry for calling you Amy.
No.
All right. Next, we are going to hear from Ms. Travis and then Ms. Holder.
I'm just going to keep my seat over here.
That's fine.
Good morning. I was asked to follow up on some of the conversation we had last time relative to what the legislature has done in the past, and there in terms of proposing legislation for compensating individuals on a basis that's not just by resolution. Last time I talked to you about what the specific resolutions have been over the last few years, and this time I'm going to talk about what the bills were that proposed statutory compensation. So both of the bills, one was 2005 House Bill 682, and the other one is 2014 House Bill 988. Both of them were called the Innocent Persons Compensation Act. And both of them, they're about 95% the same. So I'm going to talk about the similarities and then a few of the differences. Both of them had legislative findings. Both of them amended Title 28, the Financial Affairs chapter, and the Claims Advisory Board process. They both had short titles. They required the claimant to give notice, submit proof, documentary proof of the losses, specify the compensation being sought, and follow the claim process of Part 4 of this, which is a 2-year statute of limitations, but it also, both of them also opened it up for 3 years from the effective date of the act. So that gave you a time frame in which to make the claim. The board itself would make a recommendation to the General Assembly for the claimants. The claimants had to have been convicted, sentenced to prison, served time in prison, claimed innocence, and established their innocence by either a pardon from the Board of Pardons and Paroles, or a court order reversing or vacating their conviction, coupled with the indictment not being, or the indictment being dismissed or null prost, or a order granting a new trial, an appellate order, and the same indictment being dismissed or null prost. And in those last two situations where there was a trial court order of a new trial or an appellate order, it instructed those courts to give the documentation to the claimant so that they had something to proceed with. It specified, both of them specify that the compensation would not be applicable to any time that the individual was serving for a concurrent sentence. They specified that the amount would be calculated at $50,000 per year, plus an increase based on the consumer price index, plus reimbursement for any fees, fines paid, attorney's fees, or other expenses payable by a lump sum or an annuity, payable to others or after death, and categorized all of these findings as only advisory. So it was a framework, but only advisory. Then it left it to the General Assembly to decide the monetary amount, specifying, however, that that money would not be subject to state taxes except for the attorney's fees if those were paid. That there could be no offset for prison expenses, and that whatever amount was paid would not be subject to the limits of liability imposed for other civil actions. They require the board to make recommendations and give a report to the General Assembly on the list of everybody that's made a claim and the amounts. And it bars the claimant for other civil actions for wrongful conviction, but not for some other type of claim that they might be able to make. The 2014 legislation limited that $50,000 to up to 20 years. It also made it not available if the claimant pled guilty, committed perjury, fabricated evidence, made an uncoerced false confession. However, if the guilty plea was overturned, then they became eligible. Both of them provided for tuition at an in-state college or technical school. The 2014 legislation gave 120 hours, and the 2005 legislation gave a fixed amount. Interesting in context to your conversation today, the 2014 legislation dealt with the issue of expungement by saying that the Attorney General would provide legal counsel to the claimant at no cost to help with record restriction, which I think there might be a few issues involved in that, but when there is no ability to get record restrictions, that's probably something that you all would have to deal with. The only other issue that was different between the two bills was in the 2005 legislation. It provided for counseling by the Department of Human Resources for free for 1 year. So those are the two bills that have been introduced in the General Assembly over the last 10 years.
Mr. Allison.
Ms. Travis, I guess my question revolves around, you had said that the 2014 bill also included barring someone from recovery if they pled guilty. Is that what you said?
Yes.
Was there any mention in there of an offered plea?
No.
I noticed in the handout that we had that several states actually bar recovery if you pled guilty. However, the District of Columbia basically has said that the wrongfully convicted person must not have pled guilty unless there's an offered plea, which if we were going to look at something, I would highly recommend finding that language from the District of Columbia. Obviously, an offered plea is you basically saying I'm pleading guilty because I understand the weight of the evidence may convict me, but I'm still holding the fact that I'm innocent. So I would not like to see someone barred from recovery if he pled under that statute.
Yeah, I wasn't the drafter involved in the 2014 legislation. I think there's, I'm not sure what an uncoerced false confession is. There's probably some language in that paragraph that might need a little bit more work.
Hi, thank you, Ms. Travis. Ms. Holder? Thank you.
Okay. Again, not to cover anything we've already talked about today, but this little one-pager kind of just outlines all the moving pieces involved in statutes like this and a little more from the money side of things. It starts with how to pay, and again, we've talked about there's two options really, and they can be combined or individual on their own, but annuities and initial lump sums. DOAS purchases annuities, and they can be helpful because they pay out usually on a monthly basis, which can be, as some people see, an easier budget option, unlike an initial lump sum. And annuities create a cost savings for the state. The initial lump sums can be in conjunction with an annuity or just a full compensation. The state of Georgia has done both. But in 4 of the 6 compensation resolutions, the state of Georgia has done a $100,000 initial lump sum in conjunction with an annuity over a certain period of time after that. So providing funds up front can give kind of the reentry, give the exoneree the ability to get the necessities needing, like we've talked about, housing, transportation, medical services, that kind of thing. So there's a few options with how to pay, and I think they should be considered. Also, the what to pay, and that's mainly what we've been talking about. As we've discussed, the federal standard has been placed at about $50,000, and 6 states use this amount in their compensation statutes, and as Ms. Maxwell mentioned, that was a recommendation under President Bush, and has kind of stuck with some of the states. There's no specific, from what I know, calculations behind that number. Also, something to mention is an idea that I came across was one state, I believe Virginia in particular, uses Georgia's per capita personal income as their benchmark. And $38,179 was the 2013 per capita personal income for the state of Georgia, according to the Department of Commerce. And using this measurement provides a kind of a state-by-state, a more state-specific number, as, $50,000 isn't the same in every state kind of thing. But, however, something to note is that compensation of wrongfully convicted isn't just compensating lost wages. There's a lot more involved. So, again, just food for thought. And then lastly on this, a lot of states have put in minimum and maximum levels of compensation. So to kind of provide guidelines, a minimum of at least this much, but then allowing the advisory board to make recommendations based on each cases, as well as some states have put in caps, such as Florida has a $50,000 max with a $2 million cap total per case. And that kind of puts in a max for a single payout. And then lastly, as also has been addressed by multiple people today, there's additional forms of compensation, such as medical or psychological compensation, whether that's included in the intended total compensation that they've been compensated enough to find those, or whether it's separated out. Like 3 states specifically provide health care to the exoneree through the state healthcare system. And so, again, just some things to keep in mind of what other states are doing. As with education, some states provide tuition hours or waivers. I think about 8 states mention tuition assistance of some kind in their statutes. And then finally, as been addressed, fees, attorney fees add up, and that's something that some states have chosen to consider. That's it.
Any questions? I neglected to call on Mr. Todd Ashley with the Georgia Prosecuting Attorney's Office. I apologize, but we're going to give you the last word.
Thank you, Madam Chair, and representatives. It's a pleasure to be with you again. May I approach the chair?
Sure.
What the staff of the Prosecuting Attorneys Council has done is to prepare a notebook for the committee. I'm sorry we only brought one, but what the notebook contains is, at the front, a summary of each of the 32 state statutes, plus the District of Columbia, plus the federal statute, plus the ABA policy, the recommendations that the ABA makes with regards to statutes that address the compensation of wrongfully convicted. Each of those summaries is 3 or 4 sentences. It's pretty easy to read. It's pretty compact. We hope that the committee finds it useful. Behind that, you will find copies of each of the state statutes, plus the federal statute, plus the ABA guideline. If anyone wants to get a little deeper on those issues, perhaps to borrow some language or borrow some ideas or to consider some topics in the statute that have gone unaddressed in this committee.
Any questions? All right.
Good to see you again. You doing all right?
Yes, sir. You?
I'm well. Appreciate the time and coming today. I want to look at. I want to hear about this from a district attorney's point of view, and just thoughts. I'm not asking you to give positions. I'm not asking you to put your agency on the line. I'm just asking for just some ideas.
Yes, sir.
I guess the problem that I've heard today that I've already mentioned, how we can try to tie a compensation with an expungement and possibly assist folks in that process. And we have the code here. It's obviously OCGA 35.337. What do you find from your side causes the backlog with the expungements, and what would you guys think, or if y'all want to think about it and get back to me, would be a way to streamline that process for these folks? Because if they have been found to be, if there's obviously DNA testing that throws out substantial amount of the evidence, and someone were to say that this person is wrongfully convicted, we can all get off, we can find a way to expedite an expungement here, can't we?
That is probably a topic that we would be better off reporting at the next committee meeting.
That'd be fine.
With a suggestion.
I would just love to hear from y'all's side, because obviously when we find someone who's been wrongfully convicted, we need everybody to act as a team here. And I'd just be curious if y'all would just come up with an idea of what could be done, because from where I'm at right now, I don't know how we fix one without fixing the other.
Right. I understand, and I think that the representatives would find that the issue in these cases is not the prosecutors, as our friend Ms. Maxwell pointed out, and we're proud and happy to say that when these rare instances occur,
right,
it's not because of anything the prosecutors are doing or not doing. In fact, I'll go further than that and say that the exonerations are possible because law enforcement and prosecution community collects the evidence, preserves it, and presents it for subsequent testing in the first place. So against that backdrop, if you would like us to do a little legwork, come up with some language or some ideas, we'll be happy to report back at the next committee hearing.
I would love that. I mean, like I said, I understand what you guys do for a living. I have to work with a lot of prosecutors. I have the utmost respect for you, but I do value your opinion on this, because if I were thinking about doing something for the 2015 session, I don't know how we could consider education and job training for someone who, when he goes and after he gets his job training, he still didn't have his record expunged, and the first thing they do is they pull a record, see that there's a conviction there. I think we have to have a symbiotic relationship with these two if we're going to actually pull off a successful piece of legislation here. It may be two different pieces of legislation, but I think they've got to tie hand in hand for us to actually do right by these folks.
Clearly, it's a back door that ought to be closed, and we'd be happy to weigh in.
Appreciate it.
Yes, sir. Thank you.
Would you, for me, speak to the notion in the various statutes that you see that the person could not have pled guilty or participated in his conviction? Would you speak to that?
My overview of these statutes lead me to the conclusion that what the smartest states are guarding against is the uncoerced false confession. It's not a secret in the criminal justice system that a gigantic number of cases are resolved via plea. And if the key to the state coffer's lockbox was to be handed out by litigating a guilty plea again and again and again ad infinitum in an effort to get a conviction thrown out, you know, without seeing a specific legislative proposal or bill, you know, I'm not sure. Obviously, that's something that I'm sure our council would want to take a look at. But the statutes themselves speak to uncoerced false confessions. Someone made an actual confession, actual pled guilty. Right. And I'd agree with Ms. Travis. The issue of an offered plea is not addressed in any of the statutes that I saw.
Other than the District of Columbia.
Other than D.C.
Right.
And so, you know, that would be something that I think the will of the legislature would have to determine. Was that responsive?
Yes.
Kind of. Okay.
One other question, and that is, well, we haven't talked about it much this time, but the whole notion of people are being convicted on just one person's testimony, one person eyewitness testimony, and sometimes that information is faulty. If that's the basis of the whole case, then what?
With respect to the conviction itself, then those cases would obviously be reviewed at the appellate level, and our appellate courts have shown some enthusiasm in recent times to pay a little bit more attention to those. Not speaking on behalf of the prosecuting attorney's council, and certainly not speaking on behalf of our governing council, I tried a case in Fulton County that was like that got reversed because the Supreme Court removed some language from a pattern jury charge. The case was properly tried, the jury charge was properly delivered, and a conviction was had. On appeal, language that certainly the state couldn't have anticipated would have been removed from a pattern jury charge approved by the Council of Superior Court Judges and published by the Carl Vinson Institute on Government out of the University of Georgia, that our appellate court would have removed that language. By removing that language, that generated a new trial. On second trial, the gentleman was convicted again, and that conviction was reversed because of the failure of the defense to present an expert on eyewitness testimony. That's not a legal or strategic or tactical matter that the state had any standing in. I mean, how the defense attorneys defend their case is their job. And so it was reversed a second time for that reason. Again, something that is a non-state generated action through the appellate courts. He was convicted a third time. We had a jury of 36 unanimously agree that the man committed this armed robbery, and a new issue was raised on appeal by that time. But by that time, quite frankly, he had done so many years in the interest of economy. I think he had done 8 of the 10 years at that point. So in the interest of economy, it was the election of the district attorney at that time to plead him to time served and be done with it. And so with respect to that issue, every single case is different. And there remains a pattern jury charge that the testimony of a single witness is sufficient to establish a fact, whether the car was blue or whether it was Joe or John who ran from the building. If the testimony of a single witness is sufficient to establish a fact, and it's the state's job to present facts sufficient to convince a jury beyond a reasonable doubt that the defendant's guilty, those are the cards we're dealt. And that's what we have to work with.
I got one final question that is troubling to me, and that is the the committee or the compensation review committee that we use does not require us to have anybody from the legal profession to certify to the legislature that this is a case that we should compensate. You got somebody from corrections, the Secretary of State, and somebody from the DOAS or Administrative Services, but there's nobody from the legal community on that panel that helps us to decide if these are legitimate claims against the state.
From the prosecution community, or
I'm just saying and then you made me think about it when you were talking. If this committee is saying to the General Assembly that this is a legitimate claim against the state of Georgia, and we recommend that it be handled in a particular way, it's just odd to me that we don't have anybody from the legal community per se on that committee. And so do you have any thoughts about that?
If you want to put somebody, we can find you somebody.
Okay. Mr. Allison. Okay.
It was just curious to me that, nobody from the legal community is on that committee, and if we are going to give that committee more responsibility or discretion to tell us which of the cases are eligible, that raises a red flag in my mind.
And if that is advising a state committee or state agency, that would probably fall under the Attorney General. Not to throw them under the bus, but that might be something for the committee to consider.
Thank you.
Yes, ma'am.
Anybody else? That's it. Thank you so much.
Yes,
Thank you
ma'am.
for joining us, and we appreciate the work that you've given us that I'm going to give to Robert.
And I have to give credit to our staff attorneys, Laura Murphy and Jenna Fowler, for assisting in the preparation of the notebook.
Very good. All right. To the members of our committee, this is our second meeting. We only have one more to decide what we're going to do. So let's talk about next steps and what you all would like to see and how we're going to direct these wonderful people who are here to assist us. So, Mr. Harbin, you've been awfully quiet. Let's hear some thoughts from you.
I'm listening. Are we charged with coming back with?
What's your number? Okay.
25. Are we charged with coming back with recommendations that the General Assembly will follow, or just recommendations to be worked out? I mean, are we trying to come up with a hard number? Here's what the compensation should be. It should have expungement. I mean, are we just doing recommendations and then working through a committee process?
Well, it's my thought that we would come up with a model piece of legislation that we can submit to the General Assembly for its consideration through our regular committee process. I think that would be the wisest thing for us to do. Otherwise, some other committee would have to do the same thing that we're doing. So in the report back to the General Assembly, I think legislation, if we could agree to something, would be good for us to have a starting point for the General Assembly.
No, I mean, I think that, I missed the first meeting, so I probably missed a lot of the information we need. I think the 2005 legislation that she was speaking of came through appropriations back my first year there, and we were dealing with that. And that was a discussion. There was a lot of discussion then. I think that, what we need to come up with something. I don't know what that number is. We've dealt with this. Most of the time it's been at the whims of the legislature, whether, they're feeling generous or not so generous. They want to get nitpicky on it. I don't know that it's necessarily for the liability purposes of concern. I don't think that's a concern for me of us being sued. I mean, that could still happen even if you set up compensation that's too low. But I think that it needs to be done just to avoid those whims, because we've had people who've received no compensation. We've had to come back a year later or 2 years later to try to get it through just because the General Assembly was in a bad mood that day. And so this needs to be done for that purpose. And I'm assuming once it's done, it won't come to us in the form of that. Ms. Travis, will it come to us in the form of a resolution like we've been doing it? Once we pass something, wouldn't it come just as a budget item then inside of the appropriations document?
the way that the legislation from 2005 and 2014 still left it as a resolution for the General Assembly to decide.
Right, but I'm talking about my thoughts and hopes are, I hope from this study committee, is that we would not deal with that anymore, is that we wouldn't have resolutions, because all that's doing is highlighting the subject, and we start arguing over 25,000 or 50,000, and we spend hours doing it when we're letting millions run out the back door through the appropriations document. But this seems like this should be something that once we establish this, and once that person has been, they've said they're not guilty of this, and we're setting them free, and we're compensating them for being in prison, wrongly in prison, then that should just be an item within the budget document. I don't know what department you put it in, but that way, if we want to discuss it, we can pull it out and discuss it as part of that document. But to have it discussed as a resolution, it highlights it too much, for my sake, because this is something we should be doing. We probably should have done it years ago, but we can blame everyone, or we can not blame anyone. But if we're going to do this and do it right, my thoughts are we wouldn't do it as a resolution every time. It would be something we know, and it's been done. The judges made the order. Then it becomes either the governor's recommendations or the House puts it into its appropriation document, and it's not a separate resolution.
Let me walk with you for a moment with a thought. So you know that there's claims that you all pay all the time for
Absolutely.
less than $25,000, and I'm not familiar enough with the budget process. Is that like one lump sum, or?
But those claims are done, you're talking about the ones where it goes through Secretary of State, and they all work together. You're talking about like when we have someone's held at fault for an auto accident while driving a state vehicle.
Right.
Those claims, those are done individually, and those are not done by resolution, I don't think, all at one time. Those are just done as an item within the budget once they're approved by that compensation committee.
That's where I was going. So but I wasn't sure how it worked in the budget. That was my question, is those types of claims, you look at those in the budget.
Right.
And decide. Those actually go through the Claims Advisory Board. So there's a cutoff level that if they're below that amount, then they're through this Claims Advisory Board. So you could create the statutory, I'm thinking out loud without doing research, but my thought would be, if you wanted to say these types of claims are going to go through the advisory board, these are going to be the parameters, and it's just going to be a budget item, just like these automobile accidents are, and we're not going to have it done by resolution. There's edits in the law that you'd have to do, but I can't see off the top of my head why you couldn't do it that way.
I mean, because if we were to have a year where you've got 2 or 3 or 4 of these, and we get into the posture of debating these resolutions and treating people differently, and if we're trying to come up with something here that's fair, if you've gone to prison and you were not guilty, and that time that you served is worth of value, and we decide to put that on it, then that should be what happens from then on, instead of debating each one individually, trying to say, because someone is going to get hurt in that process. And I just think that it's better to do it that way and have it come to us once it's agreed that this person was wrongly convicted, they have been set free, they were in prison for this number of years, we're going to compensate them at this amount. Then it just becomes a budget item. And I just think that that's a fairer way to avoid the whims of legislature. I mean, we could change out every 2 years, and you could have a legislature that comes in, and if you're doing it through resolutions, that even if we set up a compensation or an amount that we think should be that they should be compensated, that resolution fails because of the General Assembly's changed out in 2 years. That's not fair to that person, and it's what we're doing here is for nothing then.
Let me get Tara.
Yeah.
She wants to jump in.
Just to your point, just so you make sure we're, there is a program in the Department of Administrative Services. It's called Compensation per General Assembly Resolutions, and that's primarily used for these just because DOAS does purchase the annuities, and then it's paid out through the insurer. So that is there now. Obviously, it sounds like there's other options as well, just so that everyone was aware of the budget
Yeah, I'm
programs.
just avoiding us having to vote on a separate resolution.
Agreed. I agree with that. That can still be a budget program. It could be renamed, I guess, if that's confusing. But just if you're doing the annuities way, that's a process you might want to think about. That DOAS is the one that handles those.
Well, and we could decide that here, couldn't we? If it's over a certain amount that we're compensating them, that it becomes an annuity, we're able to lump sum, which I think is fair because there's some cost that they've got to incur immediate as they're coming out and trying to get back into society.
Right. And the lump sum and annuity appropriation has always been included there because then DOAS cuts the check for the lump sum directly to the exoneree and then buys the annuity.
Yeah, I had three things, and I want to, well, it's fresh in my mind. Whatever we do, we have to take the annuity into consideration because I believe one of our wrongfully convicted is in a problem, is in an issue with his lawyer right now because his payments are coming via annuity, and I think they're in a lawsuit or something. For some reason, I thought it'd come back last night. So when last time we met, it seemed like that was brought up that there was an issue with him and his lawyer for his compensation. Was one thing. Second, to ask Ms. Travis. I think Chairman Hughley brought up a great point that if we were to set it up through the Advisory Claims Board, I don't know that a guy who might be the greatest person that knows how to pay for a road. We have Department of Transportation. What else did I write? DOAS. A lot of these people don't know anything about Department of Corrections. They don't know anything about wrongfully convicted persons. If we were going to, and I agree with Representative Harbin, I think we have to find a way that it doesn't come before the legislature every time. Would there be a way? We can't force a state agency to set up a review board the way we want it, can we? We can do a lot of things. I just don't know if we have the authority to do that. She was looking at it.
Yeah, I can go ahead and answer the question about the annuity, the first one. So the main issue with that, I believe that's Mr. White.
Yeah.
He actually did not get a lump sum, so he did not want to accept the annuity because he did not get a $100,000 lump sum from the agreements that the paperwork I've seen from between DOAS and his lawyer. So I know that's one of the issues that I think a lump sum has proven to be beneficial and should be considered, but that was where that initial contention started, and then it's escalated from there in many other ways. But that was the original origin, is that they didn't want the annuity, they wanted a lump sum in addition. Does that make sense?
So he did not get a lump sum nor did he get anything to compensate the attorney.
He had an annuity that was
Right.
paid over 20 years. The original agreement stated he would not accept the annuity because it didn't include a upfront lump sum payment of $100,000, which has been given with all but the first compensation resolution that George has done.
And that's what Representative Hartman missed when he wasn't here last time, is that we have compensation awards at $2 million, $1 million, $400,000.
Right. They've generally,
there's no
yeah,
standard.
they've gone down slowly through the years. You could blame that on pure budget timing. I'm not sure. And as we've talked about, the last two were in 2009 and 2013. So not our best budget times. But yes, you are right, is that we were originally, after the first lump sum payment, which was $500,000 in 2000, after that they were more in the $1 million to 1.2 range, and then they dropped back down.
And to answer your question, Representative Allison, so the Claims Advisory Board statutorily is the Secretary of State, the Commissioner of Human Resources, the Commissioner of Corrections, and the Commissioner of Transportation. So that's how it's set up now. It seems to me, and again, doing this on the fly, that you could say, if it's going to be this wrongful compensation, then the board either needs to be expanded or it goes to a sub-board or something like that. It would take some edits in here, but it would seem to me like you would want, I don't know if you want the board to be different because the quorum of the board makes the decision, or if you would at least want to insist on some input so that these decision makers would have, I mean, obviously they have the ability to get the input now, but maybe more forceful of the input. I mean, we're going to probably need to think through that a little bit more.
Right. I think the goal, obviously from my point of view, and there's multiple people on this committee that we need to hear from, but I totally agree with Representative Harbin. I think if we're going to solve this problem, let's solve it that we set up a standard. We all agree with that standard. We can sell that to the 236 members of the General Assembly, get the governor to sign off, and then it is delegated to someone to put it in as a line item on the budget. If not, any resolution, even if we pass a law that says it needs to be this, if someone who's elected 2 years from now doesn't like what we did and wants to try to kill it on the floor, they can do that or try to amend it, and then all this work is gone for nothing.
Right, both the 2014 and the 2005 legislation only provided a bare bones structure, but kept the resolution process in place. And that might have been because they didn't have the wisdom of a committee like this to look at
Right.
it as thoroughly.
Let me just speak to the 2014 legislation. The reason why we did not pursue that is because I felt that we need to give it more thought. And it was, it was not enough time during the legislative session. That was just, looking at what other states have done and putting together a framework that could fit within our statute based on what other states have done. And that's why we really wanted this study committee, so that we could think through those things and come up with the best scenario. But, as we, in my opinion, I think that we need a board just for the wrongfully convicted compensations that's made up of people who have the expertise to advise the legislature that, this meets all the requirements, and then it can go automatically to appropriations and that kind of thing. So in my mind, it needs to be someplace else other than those commissioners, because those commissioners are appointed, and they will have varying levels of expertise depending on who appoints them at the time and that kind of thing. And that's not their core function. You're asking them to do something way outside their core function. If we're going to if we're going to take out the step of the legislature doing anything other than paying the bill, we need to reconstitute who's making that recommendation for us, in my mind. So, what would y'all like to have Ms. Travis do for us? For us to talk about or look at next time, because we only have one more time to meet.
I personally think that we probably should stay in touch by email before the next meeting, because once we end, it's really just up to you to put something to the speaker and maybe communicate with recommendations. Of course, they'll need to be made public at the next meeting, but if we have another meeting and we're still trying to work this through, then we're not going to have a chance to put something together at a final meeting.
Right.
And so that's just my thoughts on how to approach it, because we've got a lot of ideas that we need to work through ourselves.
Right. Well, what we'll do then is we will make sure that everybody gets all the information that we have, and we will charge all of our members to make their suggestions or their recommendations, and then we will get Ms. Travis to see what that looks like when she puts all that together, and we'll send that back out to see if we're ready for a final meeting. So when we come to our final meeting, we'll be coming to finalize what we have. But if we can work it in the interim, if you all are willing to work it in the interim by sending in your individual recommendations on what you'd like to see, and then we'll send it back out when we have a draft. We'll send several drafts back out to see if we can come to a consensus by doing it that way. Will that work for you guys?
I'm fine. Can I ask Ms. Travis one more question?
Sure.
And my idea may not be what the committee wants, but while I've got you here, how do we make it where it's, because I don't want a board to go in and mess with the compensation. What I'm really talking about is a board that is going to determine if this person meets all the qualifications, and then if so, what the legislature puts into place, whether that's $50,000 a year, X for attorney's fees, compensation for education slash transitional working. How do we make it where their oversight is strictly to see if it meets these criteria, and if it's so, that calculates how many years, how many days he was incarcerated, plus this equals this is the budget line item. Is that possible, or if they still have oversight, can they just say, well, we're just not going to do that?
Well, to some degree, that is already in place.
Okay.
The the extra layer is when it's over, I think it's $25,000. Chairman Harbin might know better than I, but if it's over $25,000, which this would be, it requires statutorily, not constitutionally, statutorily, an act of the General Assembly, a resolution. So what I think you're wanting to do is you're trying to say, if it's over $25,000 and if it's a wrongful conviction, then we're going to go this route. And what you're wanting to take out is the resolution, but yet to allow the General Assembly to have input via the budget process.
As hard as it's going to be for someone who's elected every 2 years, at some point we got to take the politics out of it. So that regardless who's on that board, 2 years from now, or 10 years from now, or 20 years from now, if I don't want someone coming in and saying, well, the General Assembly said the value is worth $50,000, we decided it's going to be 30. Or somebody saying, well, we decided it's worth 80. I think we are trying to draft a guideline to basically say this is what is in place. And we want to avoid the political shifts of whatever may come in the future.
Right, and what I'm trying to say is I'm trying to say, yes, we eliminate the resolution, but let's just say,
Right.
for purposes of discussion, that it's $50,000 a year. You've got this board that has said the person meets all the criteria. They spent 3 years in prison wrongfully. They should be paid $15,000, $3,000 for attorney's fees, the
Right.
tuition, the whole 9 yards, and it should just be a line item in the budget. And then y'all are in your budget hearings. This is where I get lost because I don't know anything about what happens in the budget hearings. And that claim ends up to be $20,000 for John Smith. And y'all say, but that really should be 15. Whether, that's what I'm saying is, do you want it to be your hands tied for sure? Or do you want to have some play in the budget process?
Go ahead. You can't technically tie hands without a constitutional amendment.
Right.
So there's always going to be a budget, but if you put it in just as a document, as an item, then that says this is the dollar amount for compensation for wrongly convicted. I mean, they can still try to tweak it, but I think it's less likely unless they're trying. I mean, they try to sneak something through, but it's less likely than it is when you put that resolution out there that has to be debated and then put into the budget. If it shows up, it comes in earlier in the budget process, I guess, and so it's not trying to add something in. Like right now, we're trying to add it in at the last minute when you're in the last few days of a session. The budget's almost done, and now you've passed this item where you've got to come up with $200,000 to $300,000, which may not seem like a lot, but at the end, especially over the last few years, that's a lot of money to come up with because it's so close. So by doing it this way, if you can have it go into that document earlier, even if it goes into the governor's recommendations, where it's in that document earlier, then it's in there and it's less likely to be played with. It still can happen without a constitutional amendment. But I think after we've gone through this process, the legislature's passed a law, and then we've gone and put it out there that this is how we're going to compensate the wrongly convicted, and then it comes out as that item into the budget at the beginning, early on, it's less likely. Now, 10 years from now, quite possibly they're sitting there monkeying around with it because the economy's bad again and they want to take it and do something else. But it's still less likely. And we may have to, that may be a discussion we have to have is, should this be where it's a constitutional amendment that once that comes through this process and it goes in there, you don't touch it.
Well, the other thing that you can speak to towards future bodies is if you came up with a formula that is put in place for the advisory board for purposes of discussion to use, in 10 years from now, there's a decision that $50,000 is not right, it's too low, technology's evolved, they're owed more. The legislature could increase that amount.
Right.
So, but what you're looking for is a platform and avoiding the resolution process.
I think it's just the resolution puts too much gray area into it.
Scrutiny in there.
And I mean, it's just because it's the whims of General Assembly, and by the end of the session, we're all in a bad mood anyway. And so when you bring it up, there was a question I had, and I'm drawing a blank on it now. It'll come to me in a few minutes, I'm sure.
The other thing that we noticed last time with the resolution process is, and I think the professor brought it up. We have a gentleman who's been basically exonerated of a crime, and we attach on him mandatory drug testing. We attach on him a caveat that he has to work or volunteer. Nothing that we've ever. There's no other awards that I've ever seen in the law that come with that, whether it's a disability claim or a wrongful personal injury claim or a workman's compensation claim. I mean, it was, and that was pure politics, you know. And so I think if we could have it where it didn't come in resolution form, where it's so confrontational, and it you know, because we're gonna have a time selling this to our colleagues, regardless on either side of the aisle. I mean, there are going to be people that are going to have issues with it, and whatever we come up with may be adjusted. But I think if we can do that and put it in such a format where we can take the emotion out of it and just say right is right, wrong is wrong, and here's the formula we've come up with. If someone wants to change it 10 years from now when we're not here, there's nothing we can do about that anyway. But we can at least go to bed at night knowing we did everything we could to make this right. That's my thoughts.
Well, so this is what we're going to do then. We're all going to look at the documents, and I'm going to send y'all this book as well. And we're going to come up with our recommendations, and we're going to email. If you all will send those recommendations send them all to me, and I'll communicate them all to Jill. Or do you mind getting them from everybody? You want to get them from one source, or you want to get them from everybody?
She's saying one.
Well, you know, the only thing is that sometimes if the distilling from everybody the translation isn't always there, and it might be useful to hear what people are deciding, and then as long as the communications amongst you all can be shared, and Representative Harbin says X and Representative Allison says Y, and these are directly contradicting each other, which one do you guys want to go with? So I don't mind getting it from everyone.
Okay, so this is.
But at some point you're going to have to give a time frame for them to get it all to me, and then give me the time to come up with what to do.
Right. So this is what we'll do then. If everybody will send their recommendations to me, and then I will send them back out so that everybody will know what everybody else has recommended, and we'll send them on to Jill. But you're in no way hampered from speaking to her directly, but we're just going to do it that way so that everybody will know what everybody is thinking and talking about.
What date did you want those by?
That.
So she can have time to do something before we meet again.
Y'all think a month is enough time? And then we meet in November?
You can do that.
What about that, Jill? That sounds.
If you can, and I'd like a copy of what's in that book too as well.
Okay.
But if you gave yourselves a month to come up with a decision, and then gave me a month to come up with a draft, and when I say a month, that's like going back and forth with sending you drafts.
Well, that's December.
So then, well, yeah, that's our drop dead time. Well, we can do. This is just the middle of September, so if we go to the middle of October for our work, and then we'll give you to the middle of November for your work, and we'll try and meet before Thanksgiving. How's that sound?
I can have mine available whenever, but that's fine.
That's fine. So look, what we'll do is we'll get Ms. Williams to communicate with everybody to come up with us a date before Thanksgiving for us to meet for that final time. Okay. We have another legislator who's in here, and I don't want to close out without saying hello to her and see if she has anything for our committee. Representative Bentley, do you have anything you'd like to share with us?
Good morning. Patty Bentley, State Representative for House District 139, which is down below Macon So I just wanted to be here to learn. I'm still a freshman legislator, so I'm interested in learning about different topics and issues so I can better serve the nearly 40,000 constituents of House District 139. So thank you, Madam Chairman, for allowing me to say that.
Thank you. Well, if there is nothing else to come before us today, we're going to consider ourselves adjourned, and you all will be hearing from Stacy about the time for the next meeting. Thank you all for being here.